Good afternoon, ladies and gentlemen. Welcome to this afternoon's webinar on restructuring your business in the EU. You are welcome to submit questions at any time using the panel on the right-hand side. I am now going to hand over to Greg Chambers, our main speaker.
Hello everyone. Welcome to today's session where we're going to look at key employment law considerations when planning international business reorganisations. As Sudi mentioned, I'm Greg Chambers and I'm a Senior Associate at Osborne Clarke in the UK. And with today's focus also being on Spain and Germany, I'm very pleased to be joined by Eva Otegi, a partner who is speaking from our Barcelona office, and David Plitt, a partner speaking from our Hamburg office. We'll be joined by partners from other OC international offices in future sessions. So Eva, David and I work together on international restructurings, and we'd like to share with you today some of our key legal observations and practical tips. We've divided today's session into three areas. First is consultation obligations. It's important to factor these into your timeline. The second is statutory employee protections, such as termination payments and unfair dismissal rights. Important to factor these into your costings. And finally, we'll talk about effective planning and implementing. This will take around 45 minutes. Then we have 15 minutes to discuss questions, which some of you have kindly submitted already. Thank you for that. And which any of you can post during the webinar by, as Sudi just mentioned, typing questions into the Q&A window that should be displaying at the side of your screen. Now, in the time available, we obviously won't cover all the legal obligations and issues in each country. What we'll do is give what we hope is an instructive snapshot of the UK, Spain and Germany before concluding with our 4 top practical tips for transnational reorganisations. So what sort of reorganisations are we talking about? Well, we're considering today international reorganisations, which may unfortunately involve job losses, redundancies, and reorganisations where it's necessary to assess whether the Acquired Rights Directive applies, or in the UK that would be TUPE. Now, the Acquired Rights Directive doesn't apply on share sales. We're not focusing on share sales today. For anyone who doesn't have experience of the Acquired Rights Directive, it's the EU legislation which protects employees on asset or business transfers, and that potentially includes where a contract to provide services moves from one provider to another. It protects employees by automatically transferring them from the seller to the buyer on most of their current terms and conditions, by automatically transferring most accrued employment-related liabilities from the seller to the buyer, and by requiring employers to inform and sometimes consult with affected employees or their representatives. So our comments today are going to be relevant to companies considering international outsourcings. One example could be where a business is outsourcing customer services functions currently performed in a number of countries to a consolidated call centre in a single country. It will be relevant to international insourcings, for instance, where businesses take back in-house functions which are currently being performed abroad by external providers. We're seeing this happen in some sectors, but not in all of them. Also, our comments are going to be relevant to asset or business sales affecting employees in more than one EU country, and reorganisations within a corporate group affecting more than one EU country. So as you'll know, in the UK, our legislation implementing the Acquired Rights Directive is called TUPE. So in the UK, we talk about TUPE transfers. For clarity, Ava, David and I will all use that phrase today, but it's important to remember that different EU countries have implemented the Acquired Rights Directive in different ways. This means that a first step in any relevant international reorganisation will be to take advice on whether the local regulations transposing the Acquired Rights Directive apply or not. For instance, as a rule of thumb, in the UK, outsourcings will very often result in employees TUPE transferring, whereas in Germany, it's less common for outsourcings to trigger TUPE transfers, and in Spain it's rare. Moving to the first of our themes, informing and consulting obligations. Workforce consultation is a more prominent feature of the EU legal landscape, I think it's fair to say, than it is in some countries, for instance the US. Consultation obligations here are often triggered on transnational asset sales and on outsourcings and insourcings. This means that when planning international reorganisations, you need to ask, do you have to consult? And if so, what do you have to consult about? With whom? For how long? And could the consultation process block? Could it prevent the reorganisation going ahead? We'll cover each of these points in this part of our discussion. At the international level, you need to check whether you have a European Works Council. European Works Councils are consultative bodies set up by employers to comply with requirements for informing and consulting employees at a European level. They apply where an undertaking has at least 1,000 employees across the member states of the European Economic Area and at least 150 employees in each of 2 or more of those states. So if you're a multinational, you have a European Works Council and your reorganisation is transnational, which in this context means it will significantly affect the workforce in 2 or more different member states, then you'll need to comply with your European Works Council agreement, or sometimes some statutory fallback provisions. And that's in addition to complying with any national informing and consulting obligations. Complying with the European Works Council obligations will include considering what the European Works Council agreement says about the procedure for consulting with the European Works Council, what its operating languages are, and which countries' laws govern it. A practical consideration here is that it's necessary to carefully consider on a case-by-case basis how to coordinate the transnational with national consultation. The European Works Council agreement ought to set out mechanisms for linking informing and consulting with the European Works Council to any national level consulting. But some European Works Council agreements may be silent on this, and if they are, then the consultations with the European Works Council and the national body should begin within a reasonable time of each other. Okay, moving down to the national level, whether you have a European Works Council or not, you need to consider each country's domestic informing and consulting obligations. I'll start off with the UK before Ava and David highlight some key features and differences in Spain and Germany. In the UK, there's no general statutory duty to consult with employees about issues which affect them, unless a domestic works council or other information and consultation body exists, which over here would most often be a trade union. Works councils are much less common in the UK than they are in Germany, for instance, and we'll be hearing quite a lot more about works councils from David. But in the UK, reorganisations will always trigger obligations to inform and potentially consult employees in advance of TUPE transfers and or large-scale redundancies, which we call collective redundancies. So starting off with TUPE, as I mentioned, this is the legislation which implements the Acquired Rights Directive into UK law. And to quickly recap on TUPE, as in all EU states, one of the key things it does in the UK is to automatically transfer employees from a seller to a buyer on relevant asset business acquisitions. In the UK TUPE legislation, unlike in other EU countries, there's also an express provision that applies to service provision changes, meaning outsourcings and insourcings, provided that certain criteria are met. And TUPE can apply to reorganisations within one corporate group or to asset transfers or outsourcings outside of the group. Where TUPE applies, employers must inform employees about the transfer and consult with them about any measures, by which I mean changes, that the employees will experience as a result of the transfer. In the UK, there's no fixed time frame for doing this, but it must be in good time before the transfer. The standard obligation is to consult with employee representatives, and because in the UK, I think it's fair to say we have a less established culture of workforce consultation than in, say, Germany, these representatives quite often need to be elected specially. As for the penalty for breaching these, well, it's a fairly hefty one. If you breach the TUPE consulting obligations, the penalty is up to 13 weeks actual pay per affected employee. So you can see, depending on the number of employees, the exposure can quickly rise to 6 or 7 figures. Okay, now Ava is going to give the Spanish perspective on TUPE and its consultation obligations.
Where there is a significant transfer of assets from the seller to the buyer, and the transferred assets are sufficient to form a unit which keeps its functional autonomy, allowing the continuity of the business, only in this case. So, as for the TUPE's informing and consulting obligations, as in the UK, the seller and the buyer must provide various information to the employee representatives or to the employees directly if there are no employee representatives in the company. And such information will be given in good time before the transfer. So it's normally understood that 15 days before the transfer is reasonable, and it's also common practice. But in any case, it's advisable to start the process before the reps or employees find out about the transfer from the press or other public media. That's to avoid damaging the employees' relations. And an additional rule applies in case of mergers or demergers, which is this. The information must be provided to the employees' representatives no later than when the company publishes its invitation for the shareholder meeting regarding the merger or demerger. So that's as for the obligation to inform. Then, as in the UK, there's an additional obligation to consult employees' representatives if the seller or buyer intends to implement any labor measures as a consequence of the transfer. So when these measures involve large-scale relocations or substantial changes to working conditions, for instance, to working time, remuneration, or responsibilities, then a negotiation is required with a view to reaching an agreement with the employees. And this negotiation will last for a maximum of 15 days. So after this negotiation, the company notifies the employee representatives of its decision about whether to proceed with the measures or not. And this notification must be given 15 days before the measures take effect, or 30 days in case of, in the particular case of relocations. So the next step is that employees might either accept the company's decision or request termination of their employment if the measures would be detrimental to them. So if the employees do this, they are entitled to compensation of 20 days of salary per year of services, up to a maximum of a statutory limit, which will be of 9 months of salary in case of substantial amendment of working conditions, and 12 months for relocation. And it's also good to mention that failing to comply with these information and consultation obligations is considered severe infringement of Spanish employment regulations, and the fines range from 626 euros to 6,250 euros. So David, over to you. How's in Germany?
Hi, Eva. Thanks very much. So here in Germany, we have the same contrast with the UK in that, generally speaking, our version of TUPE doesn't apply to outsourcings or insourcings. But it is important to check each case because there can be exceptions. In terms of consultation, if there is going to be a TUPE transfer, then the first step, employers need to examine whether the national employer representative bodies have what we call co-determination rights. In Germany, we have a long-established culture of workforce consultation. So even though a TUPE transfer on its own would not result in consulting rights for a works council, if the current or the new employer is planning any operational changes to the business, for instance, redundancies or organizational changes, in connection with the TUPE transfer, then the current employer must inform and consult any national employer representative body, which could be, for example, a works council, the economic committee, or a spokesman committee, about the details of the transfer and the envisaged measure. Further, if necessary, attempt to agree two things with the Works Council. First, what we call a reconciliation of interest, and second, a social plan. I will come back to that one later on. Further, in Germany, there is no fixed time frame for the TUPE consultation, but it is advisable to start the information and consultation process with employee representative bodies at least 3 months before the envisaged transfer.
Okay, thanks very much, David. Now we'll consider whether the Acquired Rights Directive, or TUPE, can automatically transfer employees across national borders. Starting with the UK, there's quite a lot of debate about whether TUPE applies to transnational asset sales and outsourcings. We have some judicial guidance that it can do, although the matter hasn't been finally resolved. In my experience, employees working for an employer whose business is being offshored don't often want to move abroad and will prefer to take a redundancy package or to be redeployed by their current employer. Although I could possibly think of some exceptions. I might quite fancy TUPE transferring to Barcelona or Hamburg if Ava or David would like to have me over there. But practically speaking, there are three main approaches for employers in these cross-border circumstances. The first approach would be to assume TUPE does not apply across borders and manage the employees on the basis of national redundancy laws only. Second approach is assume TUPE does apply and that it will be for the employer acquiring the business or services to deal with any redundancies after the transfer. Or third, accept that TUPE applies but take steps to minimise the number of employees who will transfer. For instance, you could do that by reassigning employees to a different part of the business before the TUPE transfer. There are some strategic considerations around whether redundancies should be carried out before or after the TUPE transfer, and commercially it's important that the contractual agreements, for example the services agreement on outsourcings or the business transfer agreement on asset sales, make it clear which party will pay the redundancy termination costs or how these costs will be shared. Okay, that's the UK perspective. How about Germany, David?
Yeah, thanks, Greg. In Germany, the current indication is that there can be a TUPE transfer cross-border, but only if there is not much geographical distance between the old and the future location. In other words, there could be a TUPE transfer where the business transfer happens close to the border, for instance, southwest Germany to Switzerland, but unfortunately a transfer from Hamburg to London or Barcelona may be considered too far and thus would not consist in a TUPE transfer.
Thank you, David. There's no Spanish regulation or case law on this, but it's important to know that Spain has specific regulations regarding business relocations. So if a business is relocating to a new country, then regardless of whether there's a TUPE transfer or not, these Spanish rules on relocation would apply. So these rules would include 15 days consultation with representatives, having to pay employees relocation compensation, and giving employees a chance to object to relocation, and if they do object, having their contracts terminated and having to pay them termination compensation.
Thanks, Ava. Okay, now let's look at the separate consultation obligations which apply on large-scale redundancies. By redundancy, we're broadly referring to job losses arising because an employer can get the work done using fewer employees. Obviously, this can be a case on international reorganisations. In the UK, if an employer is proposing to make 20 or more people redundant within a 90-day period, it must consult about the redundancy situation at least 30 days before the first dismissal takes effect. And if 100 or more redundancies are proposed, it's at least 40 days before. As with TUPE, the standard obligation is to consult with employee representatives. And as I've mentioned, this process is referred to as collective redundancy consultation. Where there's a TUPE transfer, it's fairly common for there to be a collective redundancy situation at the new employer because it inherits staff from the old employer. There can be duplication of roles. So you then have two sets of consulting obligations which can cause timetabling issues because it raises the question of whether the new employer has to wait until after the TUPE transfer before it can start its redundancy consultation. Now, in the UK, the new employer's life has been made easier because some fairly recent legislative changes now allow the new employer, if it obtains permission from the current employer, to start collective redundancy consultation with transferring employees before the TUPE transfer. So that's before the employees actually become employed by the new employer. In terms of penalties, again, there's a major financial exposure for breaching collective redundancy consultation obligations, and it's up to 90 days pay per affected employee. And, which is my final UK point on this, the employer must also notify the UK government at least 30 days before the first dismissal takes effect, or 45 days where 100 or more dismissals are proposed. Failure to do that is a criminal offence with potentially unlimited fines, although they are quite rare. Okay, Ava, what's the picture in Spain?
Well, Greg, collective redundancy provisions also apply in Spain, but the thresholds here are different. Our collective dismissal rules apply when the number of redundancies is over a period of 90 days, and there are at least 10 redundancies proposed in companies employing less than 100 employees, or at least 10% of the workforce at risk of redundancy in companies employing between 100 and 300 employees, or 30 redundancies proposed in companies with more than 300 employees. So, in addition, shutdowns of operations also count as collective redundancies if there are at least 5 redundancies. So, this is as per the thresholds, and in terms of timings, employers must consult with employee representatives for a maximum of 15 days. It will be 30 days for companies which employ 50 or more employees. And after this period of negotiation, employers can take the decision whether an agreement has been reached or not. But I have to say it's highly advisable to be sure that the agreement will be reached in order to avoid the employees challenging the dismissal in court. Employers have to notify the employment authorities at the beginning of the consultation process, and the authorities will then supervise the legality of the process and also can act as mediators if required. But since 2012, since the last labor reform, companies do not longer have to get the authorities' authorization in order to carry out the redundancies. So, David, it's over to you now.
Yeah, thanks, Eva. In Germany, the situation is a bit different. I think it can be best summarized as 2 words, works and council. The employer has to inform and consult with the Works Council prior to a transfer of a reorganizational involving redundancies or operational changes, and it must do so in a timely manner, and in parallel with this, must negotiate an agreement called a reconciliation of interest and, if necessary, a social plan. But what is that? Reconciliation of interest stipulates if when and how the planned operational change will be implemented, and the social plan regulates matters such as employees' lump sum payments for job losses or for other detriments suffered. If no social plan can be agreed, the Works Council or the employer may appeal to a conciliation board, which would then be authorized to draw up the social plan itself. As in the UK, the employer must also provide a notice of mass redundancies to a state employment agency if the layoff will take place within 30 days period and provide that certain thresholds are met. This is quite important because if the employer fails to submit such a notice of mass redundancy, then all of the layoffs will be invalid.
Okay, David, it's Greg here. That's an interesting point. It's different from the UK, where there'd be financial penalties, but the dismissals would be effective in the sense that the employment would end, but it sounds different in Germany.
Yeah, correct. This is a very important difference between us and the UK, which I'll come back to when I explain about the consequences of unfair dismissal in Germany.
Okay, great. Well, we'll stay tuned for that. Moving on to the question of whether employee representatives can block transactions if the consultation doesn't reach agreement. Well, the short answer is this. In the UK, no, they can't. In Spain, no. In Germany, sometimes they can, but this kind of potential veto is more likely in the north of Germany than in the south. The slightly longer UK answer is that TUPE and collective redundancy consultation must be with a view to reaching agreement with the employee representatives. But the reps have no veto power. So if there is no agreement, or even if the employer breaches its consultation obligations, in case of a breach, the consequences would be financial and reputational. So that's potentially expensive, but the reorganisation doesn't get blocked. How's it looking in Spain, Ava?
The transfer of the business cannot be blocked in Spain, and the employees will transfer from seller to buyer. But if the employers fail to consult about proposed measures affecting the employees, the company decisions implementing such measures can be declared void by the employment courts and therefore non-enforceable. How about Germany, David?
Yeah, in Germany the position is different because the Works Council has far-reaching co-determination rights. In a restructuring involving large-scale redundancies, if the employer does not make sufficient attempts to agree a reconciliation of interest, the Works Council can seek a court order to block the restructuring. And the practical risk of a court actually granting this kind of order is much higher in northern Germany than it is, or it's more rare to be found in the southern parts of Germany.
Thanks, David. That's very interesting insight into differences within Germany as well as differences across different European states. So let's move to our second topic, termination payments and statutory employee protections. When costing a cross-border reorganisation, if there will be job losses, it's necessary to budget for termination payments. These broadly divide into payments to employees which are contractual and ones required by national legislation. The most obvious contractual payments are employees' rights to notice pay and sometimes enhanced redundancy pay or golden parachutes, either of which can be expensive. As for some of the main statutory entitlements in the UK, if an employee's employment ends due to redundancy, and if they have sufficient length of service, they are entitled to statutory redundancy pay. That's calculated using a formula based on age and length of service, up to a current maximum of £14,250 per employee. Importantly, if your overall deal context permits, redundancy dismissals should be carried out after a fair consultation exercise with the individual employee, as well as any collective consultation with their representatives. Otherwise, the dismissals will be unfair, and the employee will be able to claim compensation of up to around £80,000 or 1 year's pay if that's lower. So what about termination costs in Spain, Ava?
Yes, in Spain, Contractual notice or payment in lieu of notice provisions are not common, nor are golden parachutes. This is because the statutory termination compensations apply with the amount depending on the reason for dismissal. So if dismissals are due to objective reasons, this is based on economic, technical, organizational, or productive grounds, then the employees will be entitled to a minimum termination compensation equal to 20 days of salary per year of services with a maximum of 12 months of salary. And in addition, with large scale redundancies, the employer must contribute to fund the unemployment benefits of those employees who are older than 50. Also for employees who are older than 55, employees must contribute to fund Social Security benefits to a certain extent. And if the employer's reasons for dismissing the employee do not satisfy our Spanish law's definition of an objective reason, then the dismissals will be considered unfair, and the statutory termination compensation will be higher in this case. 33 days of service, of salaries per year of services, 45 days of salaries in case of services rendered before 2012. As a practical observation, I have to say that so-called objective dismissals very often involve litigation in Spain, as employees can challenge the company decision by arguing that the objective reasons do not really exist or are somehow insufficient. This means that it's always good to consider whether it might be better to enter into a termination agreement with the employee rather than incur in the time and the expense involved in a court hearing. So such termination agreements are quite common in Spain, especially where, due to the employee's short length of service, the difference between the compensation for a valid objective dismissal and for an unfair dismissal is small, and so does not justify the legal cost involved in a hearing. It's also important to note that for 3 years after a QP transfer, the buyer and seller are jointly and severally liable for salaries and any other employer obligations, including termination compensations, tax withholding, and Social Security contribution arrears in connection with the transferring employee. This is a major consideration in Spain. I have to say that we are aware of cases where the old employers accrued Social Security liabilities be transferred to the new employer and bankrupt the new employer. So the due diligence exercise in these cases is crucial. And David, tell us about Germany.
Yeah, thanks, Eva. Maybe it won't surprise anyone by now that the employer-related costs for such cross-border reorganizations in Germany much depend on whether the employer and the Works Council have agreed on a social plan, and if so, what the plan says about costs arising from restructurings, for example, severance payments, etc. Severance payments are most often calculated using a formula consisting of length of service multiplied by monthly gross income and a multiplier we call the decisive factor. The decisive factor often depends on the region where the business is situated. For example, in Western Germany, severance payments tend to be a bit higher than in eastern parts. But as a rule of thumb, the decisive factor is usually between 0.5 and 1.5 salaries per year of tenure. If the employer did not need to have a social plan, then costing the redundancy depends on whether the dismissals are valid or not. To be valid, certain formal requirements must be met, and there needs to be a valid reason for the termination. So if so, there is no statutory obligation to pay any severance at all, which is quite different to, for example, Spain. Although in practice, the employer and the employee usually agree on a mutual termination agreement that contains a severance payment. As you suspect from our earlier questions, Greg, the real key difference between Germany and the UK is that if a dismissal is not done properly, or in the UK jargon you could say not done fairly, then the employment will be reinstated. The dismissal itself is not effective and it's void. In certain situations, an employee may also have special protection against dismissal, for example, because of parental leave or disability or as a Works Council member. And dismissal of these employees would only be valid if permission is gained from a state body responsible for protecting employees, or in case of a Works Council member, from the Works Council itself. And finally, the employer has to inform the Works Council 1 week before the dismissal. And again, if the employer fails to inform the Works Council in a proper way, then the dismissal is void. So as a rule, this is why termination of an employment relationship by way of mutual termination agreement is very common in Germany.
Thanks a lot, David. Now let's move to our third and concluding section, where we're going to share our top 4 practical project managing tips. Our mantra here is planning and coordination. So when contemplating reorganisations which affect employees in more than one country, it's of course vital that there's a coherent overall plan which identifies the particular local risks and issues and what the pragmatic solutions are in each country, so that overall you can carry out the restructuring on time, on budget, and with no nasty surprises. So our first tip in achieving this is this. If there's a TUPE transfer and you are going to be the new employer, do your due diligence. As part of this, it's essential to determine whether TUPE applies. If so, does it apply in all the countries or just some? If TUPE doesn't apply, it does not apply, then are there any key employees you'll need to try to transfer some other way? Or if TUPE does apply, which employees are in scope? Will the new employer get the people it needs? Could it get people it doesn't want? And remember, if TUPE applies and you are the new employer, you will be inheriting not just employees, but accrued employment-related liabilities. So make sure the scope of your due diligence is appropriate in each country. For example, as Ava has explained, in Spain it must include checking whether there are any historic breaches regarding social security contributions. Okay, our second tip is this. Make sure your legal team addresses the points I've just outlined when they're drafting your commercial agreements. You need to make sure that the agreements protect you and that they set out clearly how the parties are going to share any employee-related liabilities. Third tip, a basic but key project managing principle is to appoint a senior manager to coordinate input from the different jurisdictions. And you'll probably want them to work closely with your legal team, who can help make sure that all the moving parts in the different countries work together smoothly. Our fourth tip, and our concluding remark before questions, is this. You should produce an action plan showing relevant managers the key steps and dates in each country, and a communications plan showing what local management needs to tell local employees, national representative bodies, and government authorities, and when. And this is also something you'll need to work closely on with your legal team. Okay, well, we've now highlighted some important employment law considerations and also practical points on cross-border reorganisations. And we've concluded by sharing our top 4 project managing tips. So it's time to move on to the question and answer session. And we're grateful to all of you who submitted questions. In the time available, we'll prioritise by looking at checking the 2 most popular questions, and also one that we've just seen feeds into our next webinar. If we don't get to your question now, we'll respond after the session. And please do feel free to contact Ava, David, or me directly. You can see our contact details are on the last slide. Okay, so we've had a few questions on TUPE, and the first one is this. What happens if there is a TUPE transfer but employees refuse to transfer? I'll kick off with the UK. well, in the UK, employees who refuse to TUPE transfer don't become employees of the buyer. They don't transfer. Instead, what happens is their contracts of employment terminate by operation of law on the transfer date, and they're not entitled to any statutory or contractual compensation unless they objected and resigned in response to a major breach of contract by the employer or a majorly negative change to their working conditions. So I think that's the UK answer in a nutshell. How about you, David or Ava?
Yeah, I think the German answer to this question, which I have been or come across a couple of times with clients in these situations, is as follows. After the receipt of the information about the transfer from the employer, the employees are entitled to object to their transfer with 1 month. But if the transfer of the transferee employer fails to inform the employee in a proper way, the employee has an unlimited but forfeiable right to object to the transfer. So by exercising the right to object to the transfer, the employee remains with the transferor. This may, of course, be problematic for the transferor because there may not be any possible places or employments where the objecting employee could be reasonably employed. And in such a case, the transferor will have to issue a termination for operational reasons, which may be challenged by the employee before a labor court. So it's not evident. And Eva, how about Spain?
Yeah, in Spain, the general rule is exactly the opposite as in Germany. Here, employees who refuse to TUPE transfer have no entitlement to remain employed by the seller, and they can only formally resign from their employment before the transfer takes effect. And as previously mentioned, in such case, they are not entitled to any kind of compensation unless, as we mentioned before, their opposition to being transferred is based on the new employer adopting measures such as relocation or others significantly amending the working conditions in a detrimental way. So employees who do not formally resign or request the termination of their employment before the transfer takes place will transfer to the buyer by application of the law without having to give their consent, and they should be registered with the social security authorities by the buyer. And it's only after the employee has formally communicated his or her resignation to the buyer that the employment can be understood as terminated, and the employee can be registered as an employee of the buyer for social security purposes. And there's only one exception to this general rule, and it applies to top managers or what we call senior managers. Senior managers are those managers in the company who report only to the board of directors of the company and have been granted powers to manage the whole business of the company. So only in case of those senior managers, which are not really subject to employment regulations, in case of transfer of undertaking, the managers can just object the transfer and request termination of employment, either to the seller or to the buyer after the transfer, and request the termination compensation set forth for the case of unfair dismissal in their employment contracts, or either if this termination is that provided by the law, or in case it's a golden parachute. So they are entitled to these compensations. But this would be the only exception to this general rule.
Right. Oh, well, thanks, Ava. I hope that our three answers there address the question fully. I think it gave an idea of how nuanced the different local regulations implementing the Acquired Rights Directive are. So yeah, that was question one. Second question is this: what happens to employee pension entitlements on TUPE transfers in your countries? So again, I can start off with the UK. And in the UK, you may have heard the phrase, we often say that where TUPE applies, the new employer steps into the shoes of the old employer, because most of the old employer's liabilities connected with the transferring employee's contract pass over to the new employer. But the main exception to this are benefits under types of UK pension schemes set up by employers called occupational pension schemes. If there is an occupational pension scheme, then the new employer doesn't step into the shoes of the old employer in respect of the occupational pension scheme. Instead, the new employer has to pay a percentage of salary into the employee's personal pension scheme, and there are some criteria stating what level of contributions need to be made as a minimum. So that's the basic answer to the question in the UK. There's one extra layer I'd like to share now, which is important in the UK, and that's if there's an occupational pension scheme. Again, you definitely need to do some very careful due diligence on what type of scheme it is and what the employee's particular entitlements are. That's because there are a couple of very expensive entitlements related to a particular sort of occupational pension scheme in the UK, which can TUPE transfer to the new employer, and they include expensive entitlements which are sometimes triggered by redundancies, which, as we've been explaining, could be a relevant consideration in a transnational reorganisation. So the message here goes back to what we were saying about calibrating your due diligence scope carefully according to the particular country. And in the UK, if employees are going to be TUPE transferring to you, do make sure that your due diligence looks at what sort of pension entitlements they have. Okay, that's the UK nutshell. Shall we go with, I don't mind, Germany or Spain?
Let's do Spain. So,
okay.
Greg, in Spain, using your UK phrase, the new employer will step into the shoes of the old employer in respect of the employee's employment contracts, assuming all previous obligations of the seller, including pension commitments. Pension commitments in Spain are defined by law as any obligation adopted by employers, either by law, contract, or collective agreement, to provide a benefit in case of retirement, death, and permanent disability. And I say this because employers' own internal funds are not allowed to cover these commitments in Spain. Such commitments must be backed by financial instruments allowed by law, such as pension plans or insurances. So it's important to mention that the new employer will assume any pension commitment of the seller by operation of the law, but not the contractual position of the seller in the relevant insurance policies or occupational pension plans. This means that the new financial instruments should be negotiated and undertaken with insurance companies or external pension scheme providers. In other words, when there is a TUPE transfer, you need to look not only at the cost of the company's contribution for funding the pension commitments, but also you have to consider what are the best options for taking out, for instance, insurance policies or pension plans to cover those contributions.
Okay. Again, but I think Germany, to this regard, makes reference to both to the UK and to Spain. But in a nutshell, we could say that the new employer will really step into the shoes of the old employer, because all of the old employer's liabilities connected with the transferring employee's contract, and this is sadly also true for pension commitments, pass to the new employer. Having said that, it is very important to carefully analyze all existing pension commitments before a TUPE transfer takes place, and of course, having this in mind when you negotiate your APA and making sure that the financial risks are covered between the parties.
Right. Oh, thank you very much, David and Ava. Hopefully that was an insightful brief tour around pensions on TUPE transfers in 3 countries. That brings us to the third question, which is, slightly different. It's, are things different in France? We're looking to restructure there. Okay, the short answer, and it is a very short answer in the time available, is that yes, that there are some particular considerations in France. You might be aware, actually, that France has recently gone through a string of employment reforms, and there are some more changes coming up, including regarding collective consultation. Now, if this is an area that's relevant to many of you, please do join us, I would say, on our next webinar, because we're going to be looking at France along with Belgium and the Netherlands in that. Okay, so that was our final question. If there are any others that occur to you, please come back to us. It just remains for me to say thank you from Ava, David and me to all of you for attending our webinar today. We hope you found it useful and informative, and please do look out for the next session. As I've mentioned, to discuss any aspects of today's presentation, please do contact any of us using the details at the end of the slides. So thanks again for joining us, and you may now close the window on your computer.